But the point is the district court looked at the language of Section 6.2 in isolation.
Well, let me ask you, is it going to be your position that it's ambiguous and that it should be a jury trial on the meaning of it? Or do you say it clearly states your position and it should be read to apply only to the JDP?
Yes, Your Honor. Our position is that it is unambiguous when the contract is read as a whole and when the apparent purpose of the contract is considered and the structure of the contract is considered along with the text.
So is it your position that Samsung never had any supply obligation under the agreement based on the language I think that you cite that says 6.2 imposed a supply obligation if the joint development product ever, quote, became commercialized?
Well, let me just finish answering the first question, though, and that is, but in the alternative, there is no question but that this agreement is reasonably susceptible to both proffered interpretations, whether the scope is limited to the joint development project or unlimited, as Netlist contends.
Then what happens if we determine it's ambiguous? Does it go back for a jury trial?
Well, it's a good question, and as Your Honor probably knows, courts handle that issue quite differently in terms of whether the issue just is presented to the jury as to whether there's a breach and then there's argument, whether the court gives fact questions to the jury to answer as to the disputed evidence.
Does the damages verdict continue to remain, or do they have to redo damages in light of that?
I think it would depend on the nature of the issue that would be remanded. I think that under a certain scenario, the damages wouldn't change, but under a different scenario, it would, depending upon the verdict. I think that would have to be hashed out with the district court.
I'm sorry, you
right.
Probably want to answer.
So, and I apologize. So the point is this: there was an obligation under 6.2. We don't deny that. There was an obligation to supply the memory chips in connection with the joint development project. There was an obligation to supply it during the development stage, so they had access to those chips. And if the project were successful and the NVDIMP product were commercialized, there would be an obligation to supply those memory chips to Netlist in order for Netlist to sell the product.
But on the first point that you make, are you asking us to insert language after the word products that says in connection with the JDP? I mean, that language is nowhere in 6.2. There's no language that ties it to the JDP, and there are other provisions in the contract that stand alone, separate and apart from the JDP. So how would we resolve this, what you claim to be an ambiguity, or maybe you say it's clear in the other direction, without the specific language that I think you need in that section that ties it to the JDP?
Well, there is no language in 6.1 either that says NVDIMP controller in connection with the joint development project. There's other provisions in the contract that clearly relate to the joint development project that don't also say in connection with the joint development project. That's why you have to look at the structure of the agreement in order to interpret specific language. For example, in Section 3.1, there's an $8 million NRE fee that's paid. It's clearly for the joint development project, but it doesn't say it's specifically for the joint development project.
Counsel, let's arguendo, okay?
Sure.
Let's say that I, after looking at the contract as a whole, that I conclude that Section 6.2 is ambiguous. Now, that's contrary to what both parties say, but I do say,
right.
say that's arguendo, that's what it is. What do you do with that? If it's ambiguous, how does that affect your case?
Well, if it's ambiguous, then under New York law, you have to look to the extrinsic evidence to determine what the party's intent was. And the party's intent is the controlling issue there. And in this case, the most compelling extrinsic evidence is the MOU, the Memorandum of Understanding of the Parties, which followed the exchange of two term sheets, which made clear that the memory chips were to be raw material as part of the joint development project. And Netlist CEO, Mr. Hong, admitted in his deposition that under those term sheets, the raw materials were for the NVDIMP product.
And you're making the point, you have to go outside the contract. So
right.
You have to go back for a trial then, don't you? Don't you have to go back and everybody puts in all their evidence and says all what you're saying eloquently here, and then a jury or a judge, depending which way you go, decides whether that's correct. Isn't that right?
Probably so, unless the district court would decide that the extrinsic evidence is undisputed.
But that's not true here, correct? There's evidence on both sides of the issue when you look at extrinsic evidence, correct?
Your Honor, I think that there is disputed facts in the extrinsic evidence that was offered. Our position is the MOU is so clear and compelling, and the deposition testimony of Mr. Hong is so clear and compelling, and the record shows not only that the MOU clearly included the supply obligation for the joint development project, period, that in the negotiations and for the language of the JDLA, when any deviation was made from that MOU, Netlist's position was, no. We want to go back to the MOU. That's our agreement. We're not going to deviate from it. We're not going to have any conflict.
But you're, with respect, what you're doing is eloquently arguing what you would say to the trier of fact in a trial as to why you should win.
Right.
I've practiced primarily business law for 37 years. This contract is a mass of confusion if you look at it.
Right.
Somebody has to straighten it out, right?
Right.
Okay. So are we really saying, if that's right,
right,
that this needs to go back and somebody has to straighten it out?
At a minimum, certainly it should, Your Honor. Again, we think the extrinsic evidence is compelling, but I can understand a different point of view that there are facts here that should have gone to the jury and it should have been sorted out on the whole. And that's certainly true as to the materiality issue. Because recognize